government directly, where you have a reason to believe that there is an offence involving fraud, and the offence is likely to have a material effect on the company, happening frequently, and as Sri Priya mentioned to you the limits, and the report should go not later than 30 days from the time you had knowledge of this. Need to send the report to the audit committee. If they don't take action, then again you report, and it's applicable to branch audits as well. Friends, the timing within 30 days to report, even for you to conclude, even for you to understand that there's a fraud, it could take much longer. The representations have gone out asking for 180 days time. Even if there is a potential to report, how do we conclude that you have a suspected fraud? If you look at the form which requires to be completed in this respect, it says, can you give the basis of the suspected fraud? Can you give the period of occurrence, the date it was reported to audit committee, what is the estimated amount, and the full details of the suspected offence? How can an auditor who visits them probably twice a year conclude on all this and submit a report within 30 days? Next to impossibility. Friends, on fraud, the sword is hanging right on the head of the auditors. If you compare it with the auditing standards, the auditing standard talks about financial statement fraud, which is one, fraudulent financial reporting and misappropriation of assets. Whereas the definition of fraud under this act is so vast. It could have management fraud, it could have technology fraud, piracy, breach, mass marketing, anything, electronic, online. And is the auditor responsible for all this? But how? Nobody knows. And it's 447 is not just for auditors. It's for all officers under the Companies Act. The existing standard allows the auditor to use his professional judgment to evaluate what is the magnitude of the fraud. It doesn't go laying out limits and specific quantum. The present standard, it allows the auditor to evaluate whether it has resulted in a material misstatement, whereas the new legislation even talks about an intent to deceive. Even if somebody intends, the auditor is expected to report. How? Under the present legislation in the CARO, you make inquiries with the management. You first tell them whether they have systems and processes in place to detect or prevent fraud. You go back to them saying your audit work has or has not reflected and detected any fraud or fraud indicators, and you ask them whether they had a mechanism by which they have taken care of any frauds, whether anything has been reported, and you report in your CARO. But today you've been asked to give much more details. You should report immediately to central government. Besides the auditor, cost accountant, company secretary who do not report also are liable. How will the professionals come across this at the instance when it happens? Non-performance and negligence in personal capacity alone is not accepted. Today, the partners of a firm are also jointly and severally liable under 447. Penalties: 6 months to 10 years imprisonment, 3 times the amount of fraud. If it is something in public interest litigation, then it could be 3 years RI, and of course class action suits, Mr. Arvind Pandian explained to you, it can be claimed by the promoters and major shareholders. What are the liabilities? Misconduct under NAFRA, punishment for contravention of law, and penalties for fraud, and of course refund of audit fees and class action suits. Friends, the auditing profession sits on the razor's edge. I'm sorry, there is something which has gone on. Class action suits, that was about the liability. Impact on firms. Indemnity insurance is expected to be much more expensive because it covers a larger amount. Whether they need to increase support staff to do the work. Will auditors become more conservative, asking for details of expenses and statements from managements? How would they afford to pay the penalties, and what kind of personal risk is there? Do you keep your doors open thinking everybody who comes in would be from SFIO and be ready at any time for passing on your own information and details? There are litigations which have been taken up and investigations after 12 years and 15 years by big regulators in India, whereas You preserve your own records only for 10 years. If an auditor is asked for some records after 14 years, how do you expect them to have it, especially when it was manual each time? Today, electronic you can archive, but not the manual files. Joint and several liability, all partners are liable. Auditor includes a firm for being removed, not just the signing partner. That's about the auditors who are statutory auditors. There are also two important classes of auditors: the cost auditor, their appointment and the report which he needs to forward to central government, and these standards have been made compulsory. Internal auditor also is an important class of auditors. A question which has been raised by the way the act has been worded: do all the in-house internal audit departments dissolve, or are they allowed to do audits as well? Because it talks about a chartered accountant, cost accountant, or other professionals. So that was the biggest question which has been considered. The draft rules have laid out what are the limits for which these auditors have to be appointed. Friends, I think we have a great opportunity to put down the limits of applicability of various provisions and have a software distributed to all companies by which every day they can look at what is applicable to them based on the limits, how their financials move in terms of share capital, in terms of various other parameters. I think for God's sake they should make one particular set of parameters applicable. For various provisions they've got various criteria, and somebody would really get confused on to monitor this on a day-to-day basis. There is a legal leeway available that if there is an impossibility of performance, legally the person can be excused. So I have raised certain pointers whether the auditor would at least get excused in the following aspects. Future or related party transactions. How will we as auditors who are struggling to establish completeness on present transactions be able to certify future related party transactions? In the case of revision, why should the auditor ensure distribution when there is a company secretary to do that? How do I confirm adequacy of internal controls when my directors don't confirm that at the first instance? How can I ensure that my son, brother or sister, son-in-law have not invested more than 1 lakh? What about those legal provisions under my personal income tax or the service tax of the firm be applicable for disqualification for appointment? As I said earlier, can I not avail business services as a flyer in Jet Airways or as an auditor of Apollo or buy modern bread for my consumption on a day-to-day basis? What is arm's length? Why there is no arm's length for auditors? How do I report to central government if within 30 days even the company doesn't detect the fraud? If the company had detected and the audit committee knew about it, then there's no question. Non-material and systemic issues. You send out a management letter, and when you go for the next year's audit, only the CFO is busy trying to prepare the responses because you will comment to the audit committee on status of last year's observations. So when I send out a report through email or through courier, and then within the 25th day if I don't get a reply on these regular matters, am I supposed to report to central government? On non-material frauds, there are no time limits given. So what is non-material, what is systemic, somebody has to tell. 3 times a year a fraud happens, that is it 3 times the same mistake comes in a year, or is it over 3 years? If somebody rounds off the travel bills by 5 rupees, each employee rounds it upward, is that a fraud? Because it happens frequently. So what is frequency, and how has frequency got a relevance to materiality? Okay, the responsibilities are much more for auditors in the case of these frauds. What I would like to do is to only leave these thoughts with you and end my presentation with Thomas Donohoe's quote: "The auditing profession sits on a razor edge. One excessive court judgment, even if later proven false, could destroy all the remaining major players in the auditing profession and put the financial markets to risk." My dear legal enforcers, please think about this. Thank you.
CA Bhavani for what I think was an extremely comprehensive, brilliant, and very, very subtly and well delivered presentation. Just have a couple of points on what she spoke, more from a further eye opener and opinion perspective rather than a fact perspective. Why do you think, this is actually for the audience, have we sort of been singled out, whether it's cost auditors or auditors or experts coming under fraud? Why do you think we've sort of been looked at differently? Can I have some inputs? I'm looking for something very fundamental, which is absolutely. Could you modify your response more from how they perceive us?
I think they want us to look into the fraud and report the fraud. Their expectations have gone up because of the Satyameva Jayate that you had, the fraud that happened, and they are whitewashing everybody with the same brush.
Absolutely.
And this is the thing which one could, why the sweeping changes have been brought about.
Yeah, I think what I see in this, that what he says is almost there, which is, I was perhaps just looking for one word. What I see is an extremely Western thought that sort of crept in an otherwise very different auditing domain that India has. I feel this legislation has looked at audit as an industry and not as a profession. I'll give you a small anecdote. I was at Coimbatore and there was a session which was addressed by a very senior gentleman called Krishna Raj Vanavarayar, who was the chairman of the Bharatiya Vidya Bhavan. So he sort of said, I really want you guys to come back to what you were, although I don't think you've slipped too much. And I'll just break into a little Tamil. He said, Munala Kalyanam onna vande first auditor ketrunga, and the payan nalla payana. Now in India, I think even today, Bhavani Balasubramaniam must be getting a call from top 500 listed companies, CFOs, who perhaps would be in her community, to check out about a boy.
We don't guarantee anything.
Okay, she doesn't guarantee, but she's still consulted. She gets the first invitation for a wedding. She gets the first invitation for a function. I think in India, one can, and if you look at, and when people speak about Satyam, I tend to retaliate slightly aggressively. What we see is just a microcosm of what's happening elsewhere in the world. And for 20, 30 Satyams that have happened there, India has been far less in terms of the number of scams that we've reported. And these isolated occurrences are bound to happen. So for that to pump in so much rotation and make all our lives so complicated, well, whether it's fair or not leaves to be decided. And for a single failure, I think an entire profession has been castigated. So that's the first thing. I think we are perceived more to be an industry rather than a profession, and they don't understand we're actually very, very soft. A lot of times we don't even ask for our fees or ask for a fee hike. The second thing which CA Bhavani observed was, why are there no exemptions for private companies from this rotation? Again, this act I think has been very, very strong on private companies. Now, you're talking about auditors, I'm talking about directors. You look at a closely held private company which has no bank funding. Why should you restrict a loan to a director? Why should the erstwhile provisions of 295 and 372A come in as 185 and 186 in this act? And why does 185 and 186 not exempt private companies? So today they have come right from the top. Shareholder in terms of disclosures and whatever, directors in terms of transactions with companies, and auditors. So it's everybody who sort of walked through the same path of rigor rather than anything else. So just for the thing, see, if you have two private companies which have common directors, you can't give a loan. Can't, because 185 is your overriding section. If you don't have common directors, then you look at 186 and see whether it's within those 60% limits. In fact, Sridhanya would do very well to have another program only on how private limited companies are going to be significantly impacted by this act, which is why I think an LLP conversion will very shortly be in the offing. The third point